Think about the last time you needed government permission to say something, or to go to church, or to just read a book you wanted to read. You didn't, because those are rights, and rights don't come with an application form. So why, in 2026, are millions of Americans who have never committed a crime in their lives still filling out paperwork, paying fees, and waiting for some government office to decide whether they are allowed to defend themselves? That's the question sitting in front of the Supreme Court right now. And depending on how they answer it, the country you wake up in next year might look pretty different from the one you're in today. I want to be upfront about something. This isn't a left versus right story. I know it gets framed that way constantly. It's almost reflexive at this point, but that framing misses what's actually at the center of it. At its core, this is a question about whether the Constitution means what it says. Do the words "shall not be infringed" actually bind the government? Or are they just nice-sounding language that states can quietly engineer their way around given enough time and creative lawyering? That's the real question underneath all the politics. And the Supreme Court right now in February 2026 is signaling pretty clearly that they are done watching states pretend to comply while doing the exact opposite. To make sense of all this, you need to go back to 2022. The Supreme Court issued a decision called Bruin, and it fundamentally changed how courts are supposed to evaluate gun laws. Before that ruling, states had enormous discretion. They could deny your permit application for almost any reason. We don't think you need it. The neighborhood's safe. Whatever. It was completely subjective, and in practice it meant that in certain states getting a carry permit was nearly impossible for ordinary people unless they had connections or could prove some special need. Bruin said that system was unconstitutional. The court ruled that if a state wants to restrict your Second Amendment rights, it has to point to a genuine historical law from the founding era of this country, not something from 1920, not something cobbled together from the post-Civil War Reconstruction period, but an actual documented legal tradition from the time the Constitution was written and ratified. That was the new standard, clear, specific, and grounded in actual history. For a lot of legal scholars, it seemed like a landmark moment that would finally settle the debate. And for a brief period, maybe it looked that way, but a handful of states looked at that ruling and essentially decided they weren't going to follow it. They were going to get around it. Within 18 months, 11 states had passed over 30 new gun laws, not to comply with Bruin, to get around it. And the method they landed on is something legal scholars have started calling the vampire rule. It's worth taking a minute to really understand this because it's genuinely sneaky. You know how in old vampire stories, the vampire can't enter your home unless you invite them in? These states flipped that logic and applied it to your permit. Here's how it plays out in real life. Say you're in Hawaii or New York or Maryland. You do everything right. You apply for your permit. You sit through the background check, pay the fees, take the safety course, wait the weeks or months it takes to process. You finally get the permit. You're legal. Congratulations. Then you step outside. You head to the grocery store. No firearms welcome sign on the door. Under the new law, you can't carry there. Gas station on the corner? Same thing. Bank, pharmacy, coffee shop, the park where you walk your dog. No signs at any of them. Under these laws, your permit is only valid in places where the business owner has explicitly posted a sign welcoming firearms. And here's the thing. Most business owners just don't want to deal with it. They don't put up any sign either way. So by default, the law treats your carry permit as invalid in virtually every commercial space you actually use during a normal day. You paid for that permit. You cleared every hurdle the state set up, and they still managed to make it worthless without technically taking it away. That's the trick. The permit still exists. The right it's supposed to protect doesn't, in any practical sense. Legal experts call this functional nullification. The document is real. The freedom it represents has been quietly hollowed out. A group of permit holders in Hawaii and Maryland reached a breaking point with this. They went to the Supreme Court and said they couldn't afford to wait years for this to grind through normal channels. Their rights were being violated every single day. Not theoretically, but in a very concrete, practical way. They couldn't stop at the bank, couldn't run into the pharmacy, couldn't sit at a restaurant. The permit they'd earned, paid for, and jumped through every hoop to get was sitting in their wallet, doing absolutely nothing. The Supreme Court agreed that constituted an irreparable harm, and they took emergency action. That might not sound dramatic, but it is. The court receives thousands of applications for emergency relief every year and grants a fraction of them. When they do step in on an emergency basis, it's because they've determined that waiting would cause irreparable harm. In this case, they paused enforcement of those restrictive laws while the underlying case continues. People who couldn't legally use their permits on Tuesday woke up on Wednesday in a different legal situation, not after years of litigation. Overnight. For a lot of Americans living under these restrictions, that's not some abstract legal point. That's their daily life changing because of a single court order. The ripple effects from something like this spread fast. Legal tracking data shows that lower courts have been citing Supreme Court emergency orders in Second Amendment cases at a rate roughly 40% higher than 2 years ago. Judges at every level of the federal system are watching what the Supreme Court does, even in emergency posture, and calibrating their own decisions accordingly. When the highest court in the country signals this strongly that it considers certain laws constitutionally suspect, judges below them take notice. They start reading their own pending cases differently. Rulings that might have gone one way 6 months ago start going another way. This isn't contained to Hawaii or Maryland. The signal the court sends travels through the entire federal judicial system almost immediately. The main case behind all of this is Wilford versus Lopez. Oral arguments were heard on January 20th, 2026, and one exchange in particular stood out. Justice Samuel Alito turned to the attorneys defending Hawaii's law and asked them something simple. If the state can do this to the Second Amendment, what stops them from doing the same thing to the First? Picture a law that says you're not allowed to express political opinions on private property unless the business owner posts a sign specifically permitting political speech, or that you can't wear a religious symbol in a mall without explicit written consent from the property manager. That sounds absurd. But structurally, it's identical to what these states did with carry permits. Alito was pointing out that the vampire rule isn't really a gun policy at heart. It's a template. If courts accept this logic, states have a reusable blueprint for gutting any right they find politically inconvenient. You flip the default from permitted unless specifically prohibited to prohibited unless a private party explicitly allows it, and suddenly a constitutional right exists on paper while meaning almost nothing in daily life. The other justices in the majority clearly saw it the same way, and you could apparently feel it in the room. Here's the piece that I think deserves more attention than it's getting. When Hawaii's legal team was required under Bruin to find a historical precedent for their law, they went digging through the archives, and the law they surfaced was from 1865 Louisiana. It was a black code, a law written specifically to disarm black Americans who had just been freed from slavery, designed by a racist state government to ensure that people who had just gained their freedom couldn't protect themselves or their families. Alan Beck, the attorney arguing against Hawaii, raised this directly in court. He told the justices it was astonishing that in 2026, a state was standing in the Supreme Court asking it to preserve a gun restriction by citing laws whose entire purpose was the oppression of black Americans. That's the strongest historical argument Hawaii could find. When that's where you've landed, you've lost the argument. Morally, historically, and legally. The justices could see it. The legal community could see it. Now you can too. These cases are forcing the court to address 4 questions that are going to shape gun law for the next generation, so let me walk through them plainly. The first is about how tightly the historical match has to fit. The government wants flexibility. They'd like to say that a law from any era that vaguely resembles the modern restriction is close enough. The challengers say no, the match has to be genuine and specific. This isn't a small technical debate. A loose standard essentially lets states ransack history for anything they can reframe as a precedent, which makes the entire Bruin framework toothless. A strict standard forces them to actually prove their case. For the modern permit requirement, that proof doesn't exist. There's no historical tradition of Americans lining up at a government office to request permission to carry a firearm. The founders carried. They just carried. The second question is about the gap between what a law says on paper and what it actually does to people's lives. A permit that technically allows carry but restricts it in 90% of the places you go every day isn't really a permit in any meaningful sense. It's a ban with extra paperwork layered on top. The court has to decide whether it will evaluate laws based on their real-world impact or just their stated text. This is precisely where these states have been hiding their constitutional workarounds, and closing this gap is what makes Bruin actually enforceable. Third, does Bruin apply only to outright bans, or does it also cover regulatory burdens heavy enough to render a right functionally useless? Some lower courts have tried to create room for heavy restrictions by reading Bruin narrowly, saying it only bars complete prohibitions on carrying. If that reading holds, states can keep stacking requirements and restrictions until the permit means almost nothing, without ever technically banning the right to carry. The Supreme Court needs to close that door clearly and permanently, or these workarounds will keep multiplying. Fourth, and most significantly, is there any constitutional basis for requiring a permit in the first place? In the founding era, Americans didn't apply for government permission to carry a firearm. There were no permit offices, no fees, no training requirements, no waiting periods. The right existed, and people exercised it, full stop. If the government can't point to a historical tradition of permit requirements, and so far nothing they've found holds up under real scrutiny, then under Bruin's own framework, the permit requirement itself may not be constitutional. That possibility is what genuinely alarms gun control organizations, because it doesn't just reform the system. It questions whether the system has any legal foundation at all. It's worth stepping back and thinking about who we're actually talking about. More than 22 million Americans currently hold concealed carry permits. That's a larger population than the entire state of Florida. These aren't outlaws or fringe figures. They're nurses working late shifts, small business owners who handle cash, parents commuting through rough areas, retirees who live alone, ordinary people who jumped through every hoop the state put in front of them. A study in Texas found that concealed carry permit holders commit crimes at a rate more than 18 times lower than the general population. 18 times. The states arguing that restricting permits is about public safety are working against their own data. The evidence across multiple studies is consistent. Permit holders are among the most law-abiding people in the country. The permit system isn't primarily a safety mechanism when you look at it honestly. It's a control mechanism. Whether that control has any legitimate constitutional basis is now squarely in front of the court. Understanding why these states keep fighting despite losing ground legally requires looking at who's funding the resistance. Everytown for Gun Safety and Moms Demand Action alone run on a combined annual budget of over $100 million. In recent years, they've shifted focus from passing new legislation to sustaining prolonged legal battles, coaching state attorneys general on how to draft laws specifically engineered to survive constitutional challenge while still making practical carry as difficult as possible. The strategy is essentially attrition. Keep the lawsuits going long enough, make them expensive enough, and eventually the other side runs dry. It has worked before in other areas of constitutional litigation. And in a world where a single case can cost millions of dollars to litigate through multiple courts over multiple years, a $100 million annual budget is a serious weapon. That strategy has a hard limit when it runs into the Supreme Court's emergency docket. A $100 million budget can fund years of circuit court litigation. It can't override a Supreme Court emergency order. When the court steps in and pauses a law, the expensive waiting game is over. The emergency docket is exactly what makes this moment structurally different from the years of slow, grinding, expensive litigation that came before it. The rules of the game have changed. There's another case on the horizon that deserves serious attention. On March 2nd, 2026, the Supreme Court is scheduled to hear United States versus Himmani. If Wilford is about where you can carry, Himmani is about who the government is even allowed to disarm, and the answer the court gives could affect far more people than most realize. Federal law under 18 U.S.C. 922(2)G includes a category called unlawful user of a controlled substance. If you use marijuana, even in one of the 24 states where it's fully legal, you are classified under federal law as an unlawful user, and unlawful users cannot legally possess a firearm. Get caught with a gun while also being a marijuana user, and you're looking at a 10-year federal sentence, not for anything violent, not for threatening anyone, just for having a gun in your home while also using something your state says is legal. Ali Himmani was a Texas man who had a firearm at home and admitted to marijuana and other drug use. He was charged under that federal statute. A federal appeals court looked at his case and reached a conclusion that surprised a lot of people. They said the government can't strip someone of a constitutional right based purely on their status as a drug user if they weren't actually impaired at the time they possessed the firearm. Dangerousness has to be demonstrated, not assumed, from a lifestyle category. That's a meaningful distinction. It's the difference between this person is a real threat and this person uses something we've classified as prohibited, and the court said only the first justification is constitutionally sufficient. That's a significant move. Millions of Americans in legal marijuana states are currently forced to choose between their state-sanctioned medicine and their constitutional right to own a gun. Justice Amy Coney Barrett has written previously that the government's power to disarm citizens should be limited to those who are genuinely and demonstrably dangerous, not people who use something that's federally classified as prohibited, or people who happen to be in the wrong place once years ago, not people who made a financial mistake years ago, people who pose an actual concrete threat to others. If the court adopts that standard in Himmani, the downstream effects go well beyond marijuana. People with nonviolent records across multiple categories, simple possession, certain white-collar offenses, crimes that had nothing to do with violence or firearms, could potentially have their rights restored. More importantly, the entire burden of proof shifts. Right now, the default is that once you're on the prohibited list, you're on it permanently unless you fight your way off. Under the framework the Fifth Circuit applied in Himmani, the government would need to justify why a specific individual, given their actual history and circumstances, represents a genuine public safety threat. That's a completely different standard, and it changes things significantly for a very large number of people who currently live with this restriction affecting their daily lives. It helps to zoom out and look at the actual landscape across the country because most people don't realize how dramatically different things already are depending on which state you're in. America currently runs on 3 completely separate systems for firearm carry. In 29 states, you don't need a permit at all. The Second Amendment itself is treated as sufficient authorization. You're a law-abiding adult. You have the right. You exercise it. In most of the remaining states, the government operates on a shall-issue basis. If you meet the objective requirements, they must give you a permit. No subjective gatekeeping, no official deciding they just don't feel like issuing one today. And then there are the states we've been talking about, where the permit exists on paper but has been surrounded with so many restrictions, requirements, and default prohibitions that it barely functions in daily life. These Supreme Court cases are aimed directly at that third category. And depending on how broadly the court chooses to write its final opinion, the implications could reach into the second category and beyond. Here's the thing about that third category of states. The ones that built systems designed to make your permit useless did not do it accidentally. These laws were crafted by attorneys who read Bruin carefully, identified what the ruling did not explicitly prohibit, and engineered restrictions that technically operated within it while gutting it in practice. That took deliberate effort and real legal creativity, and the Supreme Court has been watching it happen. The emergency intervention in Wilford, the pointed questions during oral arguments, the decision to take up Kipke v. Moore out of Maryland as well, all of it points toward a court that has seen enough and is preparing to draw a much clearer line. Legal analysts are talking about a national floor scenario. The idea is that the court could establish a minimum level of carry protection that every state is required to honor. The way free speech applies in every state, the way religious freedom applies everywhere, the way due process protections follow you across every border. If the court writes the opinion broadly enough, no state would be able to engineer a system that makes your right to carry practically impossible. A driver's license works in all 50 states. A marriage certificate works in all 50 states. You can practice your religion in California and in Texas without needing a different license for each. The argument being pressed right now is that a right explicitly named in the Constitution should work the same way, and the Supreme Court, based on the signals coming out of these cases, seems increasingly inclined to agree. There's something worth saying about what the permit requirement actually represents at a philosophical level, because it rarely gets discussed plainly. When the government requires you to obtain a permit to exercise a constitutional right, the implicit message is that citizens are presumed untrustworthy until proven otherwise. You have to demonstrate your worthiness before the state will allow you to protect yourself. The founders didn't build this country on that premise. The Second Amendment exists because they believed the right to defend yourself isn't something a government grants you. It's something you have by being a person. The permit system inverts that completely. It says the default is restriction and freedom is something the government hands out when it decides you've earned it. These cases are, at their foundation, a challenge to that assumption. And it is a challenge that has been building for a long time. Practically speaking, if you have a permit, hold on to it. Even if the court rules in a way that reduces permit requirements significantly, there will be a transition period. Laws don't evaporate overnight. Enforcement takes time to adjust. Your permit still provides real legal cover in the meantime, especially for reciprocity when you travel across state lines. Keep it current and don't let it lapse assuming things are about to change. If you're in one of the restrictive states, check the Supreme Court's orders list on Monday mornings. That's when they release new orders, and a single paragraph in one of those releases could meaningfully change your legal situation. It happened once already during this litigation cycle. People in certain jurisdictions went to bed without usable carry rights and woke up the next morning in a genuinely different legal situation because of one order. It could happen again before the final ruling lands in June. The bigger point, and this matters regardless of where you personally stand on guns, is that what's being decided here is about something more fundamental than firearms policy. It's about whether constitutional rights in this country are durable and enforceable, or whether a state government with enough resources and creative lawyers can quietly hollow them out while technically leaving them on the books. Every right in the Bill of Rights has faced versions of this same pressure. The right to a fair trial has been chipped at. Freedom of the press has been tested. Religious liberty has been litigated for generations. Each of those fights was, at its core, the same fight. Does this right actually constrain government, or is it just language? The Second Amendment is the current version of that question, and how the court answers it in 2026 is going to matter beyond gun policy. Something is going to give here, and probably sooner than most people expect. The states involved have real resources, motivated legal teams, and genuine political incentive to keep this fight going as long as possible. But the Supreme Court has spent 2 years sending signals that are hard to read any other way than as a court that is done being patient. Emergency orders, pointed oral arguments, a string of cases accepted that wouldn't have been accepted 5 years ago. These two things can't coexist indefinitely. A court that keeps signaling it considers these laws constitutionally suspect will eventually have to say so plainly in a written opinion that binds everyone. The ruling expected before the end of June 2026 is going to resolve that tension one way or another, and based on everything that's happened so far, it's going to land with significant force. Pay attention to what happens next, not because someone told you to, but because this is one of those moments where the legal landscape actually shifts, and the people who understand what's happening before the final ruling comes down are in a fundamentally better position than those who find out after the fact. The arguments have been made, the cases are on the docket, the court is going to answer the question it has been signaling it wants to answer for years now, and the answer matters, for gun owners obviously, but also for constitutional law more broadly, and for anyone who thinks it's worth caring whether the rights written into this country's founding document still mean something real when a government decides it would prefer they didn't.